Hello everyone and welcome back to my channel. My name is Advocate Rioba. In today's conversation, we are going to tackle civil law. This is going to be topic after topic. Every Thursday, we're going to be having civil law. In this particular video, we are going to discuss the Small Claims Court. Before we begin, as usual, I would like to urge you to subscribe to my YouTube channel and like the video, share it widely where you feel like somebody will be assisted by the information that is going to be stated in this video. So, the Small Claims Court is at the bottom of the hierarchy of courts in Kenya, but that doesn't mean it is the least busy court. I can go so far as to say that it is the court that has more cases than more of the higher courts. In the hierarchy of courts in Kenya, the highest court or the apex court of the land is called the Supreme Court, followed closely by the Court of Appeal, and then the High Court, the Magistrates Court, and then we can get the Small Claims Court. So, what is the concept and why was the Small Claims Court founded? So, the Small Claims Court is enacted by a legislation called the Small Claims Act and given power to work through the small claims rules. Don't worry about the act, it is just part of the legislation. So, keeping it simple, the Small Claims Court deals with matters from 0 shillings to a 1,000,000 shillings. So, anything above a 1,000,000 shillings cannot be handled by this court. So, it was brought up so that it can help businessmen who have debts, supplies which have not been paid that are below 1 million, and they can be handled in a very fast time. Now, these matters only last for 60 days. So the fast nature of the matters really favor people who are in business that they can have their dispute resolved as fast as possible. So this court handles personal injury claims, damages, contracts, breach of contracts, breach of payment of supplies, and so forth. It does not handle land matters, it does not handle criminal matters. So let's say you have an issue, you have supplied goods to a particular person, a client, he hasn't paid. So, and it's below 1 million, what do? You approach the court using a claim form where you fill in your details, you fill in the details of the respondent, the person you're suing, why you're suing him, how much money he owes you, witness statements, documents that you will need to support your claim, and witnesses, maybe who you will need to support your claim. So after you've instituted this suit in the Small Claims Court, the court will give you a mention date where it will tell you to serve the other party, who will be the respondent, and he will be required or she will be required to respond within 15 days of the service. So let's go to the other side. You are a respondent. You have been served with the claim that we have described on how it is being filed. What do we need? Now you do a response to claim. You say maybe I don't have money belonging to the supplier, or I paid them, or there is somebody else, a third party. So you can put a third party claim or a third party notice to a person you feel as a respondent should bear the liability wholly or part of it. You will also support your response with list of documents, list of witnesses, and witness statements which you're going to rely on the hearing. So when all of this is done, you file it also in court, and then you go back to the mention that you are served at the first time by the claim, where you comply. You say that we have responded to the claim. Because failing to respond to the claim shows admittance that you have accepted that in actual sense you really have the money for the claimant. And the court can give what is called a default judgment, where they will give a judgment in your absentia and you will be required to pay. So After you go to the mention to confirm that you've already paid, or you've already, sorry, responded to the claim, the court will issue a hearing date. So there's two ways the hearing can go. It can either go through something called a Section 30, where you only exchange documents and submissions, where you state the whole case, denying whatever you have been claimed or claiming whatever you claim. Then the court will make its judgment. Or you can go the more traditional way, where you're going to do a full hearing, where you bring your witnesses as the claimant, the respondent brings the witnesses as the respondent, you exchange documents to court as exhibits, then the court will make a determination. So it is important to note, after the judgment, you can appeal a decision to the higher courts. That's the magistrates court, the high court, the court of appeal, until the Supreme Court, which is the last port of call for any appeal. I believe this information is important for you to understand what the small claims is in its simple nature. So, in our next episode, we're going to go deeper into civil cases and more civil cases and more civil courts. Thank you for listening, and kindly subscribe to the channel and stay safe. Thank you.